Hi everyone, in this lesson we're going to be talking about race, color, and national origin discrimination. Before we dive in, let's do a quick vocabulary review. So some of the terms we've talked about thus far that we need to just keep in mind are disparate treatment. This means that people are treated differently due to a protected class. These are usually more obvious cases where it's easy to prove that somebody was treated differently. Defenses available to employers if they're accused of disparate treatment discrimination. One is a legitimate non-discriminatory reason defense, meaning there was a good reason that this person suffered an adverse action and it didn't have anything to do with discrimination. The other is BFOQ, or bona fide occupational qualification. This must be a legitimate component necessary to the job. And we clarify here, for this chapter specifically, race cannot serve as a BFOQ. The next term, disparate impact. These are the much harder to prove cases of discrimination. This usually results from a facially neutral policy that ends up having a discriminatory impact. We're usually having to rely on statistical data gathered over periods of time in order to prove that some policy has a disparate impact on some protected class. A defense available to an employer accused of disparate impact discrimination is the business necessity defense, saying that even though this policy does tend to have a discriminatory impact, it's necessary for our business to function that this policy stay in place, and we can't find a less discriminatory policy to enact. Next term, adverse action. We'll talk about this a lot. It really just means any adverse treatment, anything that an employee suffers that a reasonable person would construe as being adverse to their employment. So this can be an action or omission that takes away a benefit, opportunity, or privilege of employment, including things like demotion, removal of privileges, termination, etc. And the list of what counts as an adverse action will continue to evolve over time as more and more cases are filed, and the courts go in and decide what can and can't be considered an adverse action. Dissimilar treatment, our next term. This means, it just means that people were not treated similarly. Usually what we're talking about here is, well, this group was treated this way, while this other group was treated dissimilarly in this other kind of way, so that we can show that discrimination happened. This could mean that the position was filled by somebody not in the same protected class. Could just mean that they were treated differently than others not in the same protected class. For instance, like policies being applied differently to different protected classes, things like that. So that's just some vocabulary, just keeping it top of mind as we progress through the chapter. So discrimination can be proven by, and there are a couple different things here that we'll talk about. One is a facial policy. So this doesn't happen much anymore, at least if the employer is smart. But we used to, going back in time, it used to be common to see job ads saying things like, well, no white people need to apply, no black people need to apply, no Irish need to apply, whatever. Or saying something like no dark-skinned Indians, or, whatever. If we have an actual stated policy that discriminates based on a protected class, well, congratulations, that's a very easy case to win. But most employers don't have these facial policies anymore, again, if they're smart. We can also use direct evidence. For instance, if you're in an interview and the interviewer says, well, we don't hire black people here, or we already have enough Asians here, or this is really a white man's job. If they say something like that, then that's direct evidence of discrimination, and we can use those statements in court to prove discrimination, or at least as evidence in favor of discrimination, as long as I can convince a jury that it actually happened. Again, here's where most employers aren't going to come out and say these types of things, because most people are aware that it's wrong to discriminate, and so they're not going to say it. If accused of direct evidence, a defense an employer has is they would need to show by a preponderance of the evidence, meaning 51% or more likelihood that they would have acted as they did without regard to the employee's protected class. For instance, maybe they did say that in an interview, but it came up in a background check that the applicant had a criminal history, and that would have disqualified them from employment anyway. So that could potentially be a defense. But again, like I said, most employers aren't going to come right out and say these things anymore. We can imagine if an employer wanted to be discriminatory, but they didn't want to get into legal trouble. They're not going to have a facial policy. They're not going to come right out and say these things. They'll find other ways of trying to be discriminatory without coming right out and saying it. So that's where we get into the circumstantial evidence point. So in order to establish a prima facie case of discrimination, and prima facie, or you can pronounce it prima facie, either way, what this means is that at first glance, it looks as though discrimination happened. The prima facie can roughly translate into at first glance. In order to prove it, we have to show certain things happen. One, the person was a member of a protected class. Now, we're all members of various protected classes because we're all certain races. We come from certain national origins. We're all certain genders, whatever the case may be. But we have to prove that the person is a member of a protected class. That's usually pretty easy. Next, we have to prove that they're qualified for the job. Okay, so they would have had to be qualified for the job in order for the employer to be liable for discrimination. If they're not qualified, then they shouldn't have been working there in the first place, so then it wouldn't count. Third, they suffered some type of adverse action. That can mean not getting hired. It can mean me being fired, being demoted, whatever that adverse action might be. And then the final point is that there's some evidence here that the adverse action is linked to the protected class. Examples: the job remained open, or somebody of another race or nationality was hired for it. They were treated differently than people in another protected class. So recapping those, the person was a member of a protected class, qualified for the job, they suffered an adverse action, and there's something that links the adverse action to the protected class. That's what we call circumstantial evidence, and that's where most cases of discrimination are today, because again, people don't come right out and say they're going to discriminate. If I can establish a prima facie case, then we have this burden shifting framework in the United States under Title VII. The burden shifts. The initial burden is with the employee to establish this prima facie case. If they do so, the burden shifts to the employer to show that the action taken was for a legitimate, non-discriminatory reason. And we can abbreviate that to LDNR, and we might do that going forward in the chapter. An example would be an employee claims that they were discriminated against based on their race. But digging into records, we find out that they had 2 no-call, no-shows. This violated company policy, and they were fired as a result, or demoted, or however they're disciplined. Okay, so not showing up to work would be a legitimate, non-discriminatory reason for an employee to suffer an adverse action. So that would be a good defense. If the employer satisfies the court with the LDNR, the burden shifts back to the employee to prove that the employer's stated LNDR is merely a pretext for discrimination. And pretext we can sort of think of as like a cover story here, or an excuse. Some examples might be, well, sure, this policy was in place, but white employees were doing the same thing and they weren't punished, while black employees were doing it and they were punished. So it seems like there's some dissimilar treatment here. And it looks like the employer's stated reason, I'm messing up my letters here, legitimate, I'm fixing my notes in real time again. The LNDR was just a pretext for discrimination. Okay, so we see that burden shifting framework. First, the employee has to establish the prima facie case. then the employer can come back and say, well, the adverse action was for a good reason. Burden shifts back to the employee to defend themselves against what the employer said and try to establish through whatever evidence you can gather that the employer's stated reason was merely a pretext for actual discrimination. So that's the framework that we have in the United States under Title VII. Also included in the Title VII is what we call the opposition clause in this legislation. That makes it illegal to punish an employee for opposing illegal discrimination, in other words, being retaliated against for opposing some type of illegal discrimination. So we imagine here like a majority employee, let's say we have a white employee who's being asked to discriminate against black employees. And they know that's wrong, so they refuse to follow those orders from management, and they're not going to discriminate, and then they get fired, retaliated against for not following orders. Okay, so that is illegal for the employer to fire somebody for opposing these discriminatory activities. In order to win in court, they would have to prove that they, number one, engaged in an opposition activity protected under Title VII. Two, that they suffered an adverse employment action. And three, that there is some causal nexus between those two events. So their adverse action they suffered was related to their opposition activity, their refusal to follow orders and actually discriminate against people. Okay. So next we'll spend a little bit of time talking about what we mean by race and what we mean by national origin. And a lot of this information is going to come from the EEOC, since they're the administrative body who is in charge of enforcing these laws. So looking at the EEOC's race guidance, what constitutes race? Well, there are a lot of factors that are tied to a person's race, and I have a list here. So one of those things is their ancestry. So there is an overlap with race and national origin, although there can be different as well. They can be different. They can be similar. They can be the same. They can be different. So, for instance, we can classify a person as being Asian, which would be a racial classification. We can also call a person Chinese, which would be a national origin classification because it's specific to a nation, specific to a certain country. Physical characteristics are tied to race. So a person's skin color, their hair type, hair color, the facial features that they have, height can be sometimes linked to race, weight, sometimes, possibly. Race-linked illnesses can be tied to race. So there was a history of companies trying to sort of skirt around Title VII protections by just saying, we're not going to hire anybody who has sickle cell anemia or something like that, which was sort of a proxy way of discriminating against black people. So some illnesses are linked to specific races like sickle cell, like diabetes, potentially because we find that certain people groups tend to be overweight more and tend to be susceptible to type 2 diabetes in greater numbers. Those are sort of edge cases there, but certainly something to think about. If the employer applies facially neutral standards to exclude treatment for conditions or risks that disproportionately affect employees on the basis of race or ethnicity, the employer must show that the standards are based on generally accepted medical criteria. So it doesn't mean that you can't have some type of policy in place regarding some of these health conditions, but you can't just base them off of trying to discriminate against certain protected classes. Culture linked to race. So a person's name. Sometimes you can look at names and sort of have a somewhat educated guess as to what race that person might be or what country they might be from. The way that people dress can be tied to race. Grooming practices can be tied to race, like the way that people do their hair and things like that. And the accents that people have when they're speaking can be tied into a person's race. We'll take just a second to talk about perception, because also covered under Title VII protections is the employer's perception. So for instance, even if a person isn't in the particular group, if I discriminate based on my perception that they are, then I've violated Title VII. For instance, I see a person that I think looks Asian and I discriminate against them because I have something against Asian people. It turns out that they're actually Latino or even white. I've still violated Title VII because I acted based on my perception. So they're still covered, even if it turns out I was wrong the whole time and I just got my discrimination mixed up. Association is covered because a person might be married to somebody of a different race or just have friends that are of different races or different national origins. This association is covered even if the employee is a member of a majority group. If I discriminate against them because they tend to associate with people of different protected classes, that's a violation of Title VII. Subgroup or race plus discrimination, also covered. So here's where we can start picking and choosing different subgroups of certain protected classes. So for instance, I could say, well, single black people are fine. Single white people are fine. White people with kids, fine. But I'm not going to hire a black person with kids because I have something against the way that people act when they're black and have kids. Okay, that's a violation of Title VII. I could say that, okay, I'll hire white men or white women, that's fine. I'll hire black men, and that's fine. But I'm not going to hire a black woman. Okay, that's a violation of Title VII. So, we're considering cases where people go in and they're a little bit more specific about how they discriminate based on these protected classes. The final point under the race guidance here that we're talking about, and there's more to it if you want to follow that link and just read more about what the EEOC has to say about it. I'm picking out sort of the main categories here. The final one we talk about is reverse discrimination. So Title VII does protect everybody. It protects the majority parties as well as minorities. So discriminating against in the United States, for instance, let's say white people are of the majority for now, and that racial makeup of the United States can change over time. But anyway, for right now, let's say in the workplace that white people are the majority party. And so you can't discriminate against white people and just say that's not discrimination and that doesn't count because they're in the majority. They would still be covered under Title VII. Now we talk about what constitutes national origin. So this can encompass the place of a person's birth. Now, citizenship is another matter because where a person's born doesn't always necessarily correlate with what citizenship they have. It can include ethnic characteristics, physical characteristics, linguistic, or cultural traits closely associated with a national origin group. And again, national origin, we're thinking of people coming from certain countries. Maybe they immigrated from a certain country. Maybe it just looks like they're from a certain country, or they talk like they're from a certain country, whatever it is. Whatever it is that associates them with some national origin. And then we have sort of a bulleted list here. So the person could be associated with a person of a specific national origin. So again, association is covered if you're married to or friends with or have other family members who are of some national origin, still covered. If a person is a member of an organization associated with a national origin, even if they aren't of that national origin, just being a member of that organization would count under association. If they participate in school or religion associated with a national origin, if they have a surname, that just means last name, generally associated with a national origin. If they are perceived to be a member of a particular national origin. So a lot of that sounds familiar with or similar to what we talked about under race. And it's because they're closely tied. No accommodation is required from employers for national origin, except when there might be some tie-in with religion. So what that means is an employer doesn't have to allow traditional garments or grooming habits. If a person from a certain national origin from a certain country tends to dress a certain way or tend to groom themselves in a certain way, the employer doesn't necessarily have to accommodate that or allow that until it starts to overlap with religion. And now we have a different consideration entirely, because employers do have some duty to try to accommodate people's religions. So, and even if we find that overlap with religion, we only have to accommodate up to the point that it doesn't interfere with the actual performance of the job or cause some type of undue hardship on the employer. So what if I, as an employer, want to establish a rule at my company that everybody has to speak only English at all times, no matter what? We get into a little bit of tricky territory here. I could even have an English fluency rule where, you can't have too thick of an accent or something like that. All right. So I just have to be careful about that. So it can be allowed sometimes. So for instance, if I can show that it serves some legitimate business purpose, such as promoting safety, would be very easy to show, efficiency of the workplace, communication with supervisors, coworkers, and customers who only speak English, then I can justify that rule. But it gets a little trickier, a little harder, gets me a little bit more trouble possibly if I start enforcing it like when employers are on break times, like at lunch in the lunchroom or something like that, and I hear somebody talking in their native language, and then I go in and try to tell them they can only speak English. That's the kind of thing where it could potentially get me in trouble as an employer, so I'm going to try to avoid that. We also acknowledge here that tied to race and national origin is the post 9/11 environment that we live in now. Some of you are probably young enough to where you were not even born on 9/11. But anyway, it did have a huge impact on this country in the way that people in this country view Middle Eastern people. So Arabs, Muslims, anybody who looks vaguely Middle Eastern were subjected to increased discrimination post 9/11 because people were just very suspicious of anybody who looked vaguely Middle Eastern. We have seen a few high-profile cases and some lower-profile cases where they revolve around whether a woman, specifically a Muslim woman, should be allowed to wear the hijab in their workplace. So can they wear the headscarf? Or more specifically, can an employer require that they not wear it? So one case was Abercrombie & Fitch in 2015, where an applicant came in wearing the hijab. They weren't hired because Abercrombie had a very specific company look policy, and that didn't fit in. And then they sued. It went all the way to the United States Supreme Court, who decided that this could be considered to be employment discrimination. Disney had a high-profile case in 2012 where there was a woman who was working there as I believe she was a ticket taker, but in different parts of the Disney parks, you have to wear different uniforms. They're considered to be cast members, not just employees. You're playing a part. You're creating the magic that is Disney. And about a year into her employment, she had avoided wearing the hijab because she didn't want to cause a ruckus. But about a year in, she just started wearing her headscarf, and she was taken off the schedule as a result. And there was a couple compromises that were proposed. Maybe she could be put in a part of the park that she doesn't have any interaction with customers. She would have considered that an adverse action. They even pitched an accommodation where she would wear a hat that would fit that part of the park on top of her headscarf, and she didn't like that. It was ultimately settled out of court for an undisclosed sum because Disney didn't want this dragged throughout the courts, but it's the kind of thing that employers have to think about nowadays when they're deciding if they're going to cause a stir over this. Now, when we're talking about national origin, one big piece of legislation we need to talk about is the Citizenship and Immigration Reform and Control Act, also known as the IRCA. This was passed in 1986. It makes it illegal for an employer to knowingly hire or recruit undocumented immigrants. Prior to this, it was illegal for somebody to work in the United States undocumented, but it wasn't illegal for employers to actually hire them. So this was an attempt to fix that. Under Title VII, it does not prohibit discrimination on the basis of citizenship, except where it would have the purpose or effect of national origin discrimination, or where it would be the pretext for national origin discrimination. So Title VII really only touches on citizenship where it would be used as some sort of proxy to discriminate based on national origin. There is a political function exception here. Some positions in the United States will be limited to United States citizens by statute. Rules valid in connection with certain non-elected positions held by officers who participate directly in the formulation, execution, or review of broad public policy. So some of these positions might be limited by statute to citizens of the United States. But otherwise, it makes it illegal to, for some types of discrimination. We'll get more into that here. And we're thinking about somebody who maybe they're not a citizen of the United States, but they have a work visa to work in the United States. So that's kind of what we're thinking about here. So keep that in your mind. So the IRC prohibits discrimination based on origin or citizenship or intended citizenship. So it prohibits hiring aliens not authorized to work in the United States. I'm not using the word alien as a derogatory term. It's just somebody who is from another country, not a U.S. citizen, not authorized to work in the United States. It allows for an employer to enact a preference for a U.S. citizen if faced with equally qualified applicants. So if I have two equally qualified applicants here, one is a U.S. citizen, one is not, then I can, as an employer, have a preference for U.S. citizens. Anti-discrimination provisions cover employers with between 4 and 14 employees with regard to national origin, and 4 employees and up with regard to citizenship. It covers 4 to 14 employees with regard to national origin because once you have 15 employers or more, then Title VII kicks in. So we don't need the IRCA for national origin. So then it covers employers with 4 employees or more regarding citizenship specifically. 2 bona fide occupational qualifications are allowed under the IRCA. One is an English language skill requirement, reasonably necessary to the normal operation of the business or enterprise. The other one is citizenship requirements specified by law, regulation, executive order, or government contracts. So it can get very complicated here when you have to understand the specifics of various laws, regulations, executive orders, contracts, yada, yada, yada. So it just means that if you're an employer, you have to do some research to understand whether or not what you're doing is correct. So a big difference between Title VII and the IRCA comes with proof of discrimination. So under Title VII, we do not have to show proof of discriminatory intent. An employer could do something that's discriminatory without intending to do so, and then still be held liable. Under the IRCA, it requires the discriminatory adverse action to be known and intentional. making innocent or negligent discrimination a complete defense to a claim of discrimination under the IRCA. So much more difficult to prove discrimination under the IRCA than it is under Title VII. But the IRCA will cover some things that Title VII doesn't. As far as undocumented workers go, there used to be this double standard. I mentioned earlier, there used to be this double standard that made it illegal for undocumented workers to work in the United States, but it wasn't illegal for employers to hire them. So the IRCA comes in to try to fix that double standard. This all revolves around this very familiar rhetoric and worry in the United States. People worried about undocumented workers coming into the United States and stealing American jobs. You know, your opinion on that can be informed by your political beliefs. I'm not going to jump into that or try to influence your thoughts on that. We're just stating why the legislation is the way it is and sort of how it originated. So an employer is required to verify new hires with this Form I-9, and I give you a link to where you can go actually download the form. I think you can do it electronically nowadays. And there's an exception made for temporary agricultural workers working under this H-2A visa. So again, this landscape can be a little bit complex. So if you find yourself in an industry where you're working with people from other countries who might not be U.S. citizens, or maybe they need a specific visa to work in the United States, then you have to stay on top of this just to make sure you're complying with the law. Switch gears just a little bit here, still on the same topic, but let's talk about some of the differences between disparate treatment and disparate impact. Again, disparate treatment is that more in-your-face, easy-to-prove type of discrimination, where with disparate impact, we're relying on statistical data and a policy that doesn't look on its face to be discriminatory. So starting with disparate treatment, there can be a few different things happening here that would qualify as disparate treatment. One of those is animus. So racial animus, national origin animus, whatever it is. It's a conscious decision based on animus toward a race or toward a person's color or toward a person's national origin or whatever it might be. So you could have a company owner or manager saying something like, as long as I'm running this company, I won't have a black man doing a white man's job, or something like that. And again, it's like I said earlier, employers don't say these types of things anymore. Most companies aren't discriminating or aren't trying to discriminate. It's the minority of people who still hold discriminatory beliefs, who still want to discriminate, but find subtler ways of doing it that hopefully will avoid legal trouble for them. Another thing to show disparate treatment is stereotyping or bias. This is less conscious, but more just based on stereotypes that we might hold in our mind or biases that we might hold in our mind without being fully aware of them. So making some statements like, we're looking for a, quote, clean cut image, or this is a sophisticated upscale location. I have to make sure the people I hire have, the, quote, soft skills that we need. Kinds of statements where I'm going to be excluding certain people with certain clothes, certain hairstyles, certain whatever it is I'm looking for. And rather than coming right out and saying it, I'm saying these sort of weasel word type of things. I'm going to fix this spacing here while I'm looking at it. That annoys me. All right, there we go. Steering or assignment. So placing people based on race. So think about a sales job where I'm going to be going out and working with people in that community, in that territory. And I say, well, this territory right here is very heavily Asian, so I'm going to put the Asian salesperson in that territory. Or this territory's trends much more majority black, so I'll put the black salesperson in that territory. And that might make sense to me because that person would go in there and maybe they'll be able to relate to that population better and be able to sell better to that specific demographic. So it seems like I'm doing something that's good here. But it might not be good if we can show that those territories have much less opportunity for a person to make sales, to make commission, to make money. So that's something I have to keep in mind if I'm steering people toward placement that might leave them with less opportunity than people in other territories, if I'm basing it on race or national origin. Finally, yielding to customer racial preferences. Some people might try to defend their actions by saying, well, our customers really don't like to see black people working here, or white people working here, or Asian people working here, or Indian people working here, whatever it might be. But that's not going to be a good defense for me as an employer in court. I can't just yield to customer preference in order to discriminate based on, well, any of the protected classes, really. Okay, so that's disparate treatment. How about disparate impact? Well, I have to prove the statistical demonstration that this, whatever the practice or policy is, causes this disparate impact. Again, I'm not intending to discriminate here, but through the data, we can show that because of this policy, it has this impact on a protected class. The employer has a burden to demonstrate that the policy or practice is job-related and consistent with business necessity. If the employer successfully proves this, the burden shifts back to the person challenging the policy or practice to show that a less discriminatory alternative exists that still meets the business need. So we're thinking about our recruitment practices, hiring and promotion criteria, layoff and termination criteria, appearance and grooming standards. It's okay to have appearance and grooming standards, but we have to make sure that they're consistently applied and business related. Educational requirements. Okay, this is something that's a hot topic now. If I'm doing things correctly, if I'm being smart, I should be able to prove that if I have an educational requirement, I should be able to show that it's actually necessary, rather than me just putting up some paper barrier there to keep certain populations out. Whatever experience requirements I'm putting on a job, whatever employment tests I'm using to screen people out for certain jobs. If we can show that there's a disparate impact, I have to validate that test. If we can find a less discriminatory alternative that still meets my need, then I should use that, the less discriminatory alternative. So disparate impact cases are notoriously difficult to prove. We're usually going to be dealing with very large companies where we have a lot of data that we can use. So it doesn't really affect small companies all that much. But something, if you end up working in corporate HR, this is the kind of thing you might have to deal with. Now let's assume that somebody has filed a lawsuit, and we can consider this from either side as the employee or the employer. And the EEOC is going to go in and do an investigation to try to figure out if it looks like there's actual discrimination happening here. What factors are going to be taken into consideration? Well, we can take several things into consideration. Statements made by decision makers or influences, whether they be oral or written. Okay, we can bring those into court and use those as evidence. Comparative treatment evidence. Was the employee treated the same as similarly situated persons of a different race or nationality? What are the relevant background facts? What were the employer's treatment of other persons? What were their race-related attitudes? What was the work environment generally? What was the context of the specific action? We can also look at relevant personnel policies. So an employer's deviation from an applicable personnel policy or past practice can support an inference of a discriminatory motive. So if I have this personnel policy in our company policies and I deviate from that, that could support this presumption or this inference that there's some type of discriminatory motive at play. On the other side of that, conversely, acting in conformance with or consistent with a consistently applied non-discriminatory policy or practice would suggest that there is no such discriminatory motive. We can also look at the decision maker's race. Now, this can be a factor, but not necessarily. The race or nationality of the decision maker may be relevant, but is not controlling. In other words, it should not be presumed that a person would not discriminate against members of his or her own race or nationality. We can't just assume that since it was a black person doing the hiring and managing, that they won't also discriminate against black people. Or if it's the white person that's running things, we shouldn't assume that they won't discriminate against white people, because over time we've shown that this does happen sometimes. So it's something to take into consideration, but it's not controlling. It's not determinative. And then finally, we can look at statistical evidence, specifically when we're talking about disparate impact claims. Then we shift gears a little bit again to talk about harassment. So harassment can take place based on any of the protected classes that we'll study in this course. And it can be actionable. And then whether or not certain factors come into play can depend on what protected class we're talking about, how severe or pervasive is this behavior in order to prove harassment. So harassment is actionable if it's so severe or pervasive that the employee reasonably finds that the workplace is hostile or abusive. Key words here being unwelcome and severe or pervasive. We'll define unwelcome as conduct that unreasonably interferes with an individual's work performance or creates an intimidating, hostile, or offensive work environment. Common concerns include things like ethnic slurs, workplace graffiti, other offenses based on traits such as an employee's birthplace, culture, accent, skin color. That's not a complete comprehensive list, but it's something we can use as examples. Now let's talk about severe and pervasive, those keywords. So the more severe conduct is, the fewer occurrences have to happen to prove harassment. Even one occurrence can be sufficient if it is severe enough. There was a recent case, 2015, that's relatively recent as far as the law goes, that even a single utterance of a racial epithet could be enough to prove harassment, racial harassment, in the Fourth Federal Circuit, which includes North Carolina. And I gave you a link to that case if you want to go learn more about it. Now, the less severe the conduct is, the more occurrences would have to happen. It would have to be more pervasive. How often does it happen? So severe, just how severe is the conduct? Pervasive, how many times does it happen in order to prove harassment? Employers can be liable for harassment that happens at their workplace if the employer failed to take reasonable care to prevent and promptly correct the harassment, or if the harassment resulted in a tangible job action, like a person being fired or felt like they had no option but to leave because they were being so harassed so severely. The court would look to whether the conduct was physically threatening or intimidating, how severe it is, how pervasive it is throughout the working environment, whether a reasonable person would find the conduct offensive, and how did the employer respond. So employers have a responsibility to prevent or correct harassment, but the responsibility is going to be limited to what they know or should have known about. So if the employer has been made aware that harassment is happening, if an employee comes to them and says, this person is harassing me, then they've been made known. Now the employer has a responsibility to go in and do something about it, to take some type of corrective action to prevent this harassment from continuing. And if they don't, then the employer can have liability. Now, if it's stuff that's happening behind the scenes and the employer does not have any awareness about what's going on, then they could have a pretty good defense in court later on. In order to prove harassment, we need to be able to show certain things. 1, the victim belongs to a protected group. Again, that's usually pretty easy to prove. 2, they were subjected to unwelcome harassment. 3, the harassment was based on a protected characteristic. 4, the harassment affected some term, condition, or privilege of their employment. And then finally, the employer knew or should have known about the harassment and they failed to take prompt remedial action. So we're talking about race and national origin specifically here in this chapter. But again, harassment can take place based on any of those protected classes. So we'll talk about it probably in each one of the chapters that we talk about dealing with discrimination. And then we'll have an entire chapter dedicated to just sexual harassment, because that's one of the most common harassment claims. Finally, here in the notes, I gave you some links to some North Carolina specific laws if you want to look at. So what we did was we talked about mostly about the federal protection here. And then I gave you some links to where you can look at North Carolina specific laws. North Carolina pretty much just follows in line with the federal requirements here under Title VII. But then they add some additional protection for things like sickle cell, anemia, a person's genetics. That's also protected at the federal level. And then a link to some of the equal employment opportunity laws in North Carolina. Those apply specifically to state employees. That's enough for now, and I hope you all have a great day.